Welcome to Objection to the Form. Before we get started today, I want to send a special thanks to Tron and Kansai of Minds One for providing us with the theme song for the show. It's off a great album, Pillars. It's my favorite Minds One album. They're a local group, and you should really check their music out through any of the available streaming services. Today I've got a special guest. It's Jimmy McGee with the McGee Law Firm. Jimmy's been a Wilmington native for approximately 30 years, I believe. Practices criminal law at the McGee Law Firm downtown, and Jimmy specializes in DUI law and various other criminal matters. So I'm real excited to talk to him today about DWIs and kind of the current state of legal affairs in light of the COVID-19 situation. So thanks for coming on, Jimmy.
Thank you for having me. Want to tell everybody in the bar and restaurant business we're thinking about you guys, and thank you for having me in this time. Glad to be doing something other than in flip-flops playing with my kids today and ready to get back to work.
Yeah, and that's one of the things, the first video I did was about COVID-19, and it affects everything we do, but I really kind of wanted to talk about, I don't want to dwell on it the whole time, but one of the things that came up in the first video I did kind of an update on how COVID-19 is affecting the legal field in particular. And one of the questions I discussed is, what happens if you get arrested? And I believe, that things have changed a little bit. And kind of my answer was, or what happens if you get a crime was the question, or if you commit a crime. And my answer was that you get arrested, but I don't think that really fully gets in depth to how things have changed. I was wondering if you could address that.
Well, right now I'm in the courtroom maybe once a week rather than every day. What's happening now is if you're arrested and you're in custody, meaning that you're in jail in the New Hanover County Jail, then you are entitled to due process. You're entitled to have a bond hearing. You're entitled to have your first appearance and be told what the charges are against you and how much time you could be facing on those charges. So they're a very important aspect of the court system. The courts have ensured that that is happening. Those people are able to have their attorneys in the courthouse now, and I have been there for people that have been in jail, and we've had bond hearings, and I've been able to get some people out of jail for that. That's what they're doing right now. Typically when you get arrested, a bond is set, a secure bond in a lot of cases. Now we're seeing less secured bond cases because they don't want people to be in the jail, because we're going to have to possibly quarantine them for 14 days. We don't want to have some kind of breakout of COVID in the jail system that we have and somebody dying of the virus or exposing others. So I think that's the reasoning, and we're having less arrests. Right now, the police department has been told, I think, and State Highway Patrol to stand down, not to arrest people, so you haven't seen as many police officers, maybe in a median or something like that, but you're not seeing a lot of people pulled over, especially I live in Wrightsville Beach.
If you do happen to get pulled over and arrested for some reason, is it taking longer before the bond hearing will take place than it usually would?
No, they are set up to have hearings every day. They're doing them Monday through Friday. They've actually, in New Hanover, they're doing them at 11 a.m. and Pender County, they're doing them also in the morning. I'm not sure if it's 11 a.m. there. Brunswick County, they're doing things, courts starting at 9 o'clock for the custodial cases. Those are the people that are in jail.
When you say the officers have been told to stand down, what do you mean by that, or how does that affect things?
Right now, what I've been told by somebody is not to arrest somebody unless absolutely necessary. I've kind of seen that with my practice. I used to get calls I was slammed every week. The phone isn't ringing because people aren't getting arrested. I know ABC sales are skyrocket. I know I'm at the beach. I was out on the waterway Sunday. People are drinking. People are on their boats drinking. They're on their cars drinking and driving. But there aren't a lot of arrests because I think a lot of it's the COVID-19 effect that's happening right now.
What type of cases are you seeing where people are getting arrested?
Breaking and entering cases, a lot of those cases. The public defender's office has been busy doing a lot more of breaking and entering. Then there's a ton of domestic stuff. Domestic violence is up People are quarantined together. They may have been in bad relationships already. I was at first appearances in Brunswick County. There must have been, on a Monday after a weekend, there may have been 7 different cases of domestic violence, from a female hitting her significant other with a miniature baseball bat to a guy who hit his wife with a sandwich. I mean, so you're seeing all kinds of different stories, probably some drinking involved in some of these different stories, but these folks were having first appearances because if you're in a domestic relationship, meaning that you live together, and somebody's called about an assault, you get arrested and a magistrate can't set your bond, so district court has to set a bond. They're in our jail for at least over the night. Then we have to figure out what to do with those people so they don't expose others that are in there. So that's kind of...
And that was going to be my question. And I think what I've seen a lot of times in the domestic arena, a lot of times the accused will be under a no contact order by the matter as a condition of release. Are you seeing that they're allowing the defendants to go back to their homes, back to the relationship, or how's that handled?
No, and that's always when you're trying to get a condition of bond, meaning no contact, you have to have input from the victim, alleged victim. And therefore, the victim would have to either be present at that bond hearing saying that we want contact, or that person is gonna have a tough time. The only time they could go back to their house is with a sheriff to go get their things and stuff like that. So it could be very difficult, especially in these times when, say, you are furloughed right now and aren't working, and you're working from home. It could be detrimental if you got some kind of criminal charge. Now, I recommend if you're in a bad relationship that you may find some other place right now if you could, because you don't want to be in a situation like that.
Well, to shift gears a little bit, I'd like to bring up our topic of the day, which is going to be DWIs. And I know that's kind of what I've always known you for, is that and other areas of criminal law in this area. And kind of the question I get from a lot of my friends sometimes is, well, what do I do if I've been drinking and I get pulled over? Do you have any generalized advice about that situation?
Generally, with DWI, and I always get this whenever I'm out, whether I played golf with everybody and we had a beer, what do I do if I ever get pulled over? Well, it is legal to have something to drink and to drive, but not too much. But I always say be polite. When you see blue lights, what I recommend is pull over as quickly as possible. Put your turn signal on. Officers are looking for different clues of impairment. One clue is, did you respond properly for the blue lights? That's the first thing they're looking for. If you've been out drinking at a restaurant or playing golf, don't get on your phone to text. You can't do it anyways, but don't do that, because officers are looking for lane violations before they put on their blue lights. They're looking for somebody speeding, is what they're looking for. When you get pulled over and the officer is in his car, don't jump out of your car. I've had somebody jump out of his car like this. I mean, you stay in your car. Get your documents ready. One thing that the
what documents are you talking about?
When the police officers come up, they're typically going to ask for your driver's license and your registration. Sometimes they only ask for your driver's license, but one reason they're asking for the 2 different documents is because they're doing a divided attention test. Typically, we're going to have our driver's license in our wallet. We have our registration in either in our console or our glove compartment up here. So they're looking to see if you can do 2 different things. That's what I call the first divided attention test that they give you. They're also going to ask you, have you been drinking? One thing today is, today walking into your office, I saw several people wearing masks. I was at the bank, people were wearing a mask. Will people be wearing a mask? Will that be part of our garb that we wear every day? So one thing is, if the officer pulls you over and you have been drinking, I'd probably say, keep your mask on, okay?
That's a good point. And that question, the have you been drinking, it's kind of I guess like a catch-22, because if you say yes, then I imagine you're opening the door to further testing and field sobriety, and it can be used against you in court. But then if you say no, you certainly don't want to lie to a police officer in an investigation. Is there any tips you have for how to handle that question?
There's no good answer there. Here's why I say that. You say no when you smell like alcohol, or you blow into a breathalyzer and then there's a number that they see, but they can only say you're positive for alcohol. They say that's what a drunk does, okay? If you say yes, the next question is how much. You're not under oath. I don't admit that you say, I had 18, I don't. I would tell you, if you are going to talk about you had drinks or beers, don't call them whiskey, shots, Jaeger bombs. I would not use that kind of language when talking to the police officer. I've had experience with high octane beers, things like that. Those are language not to use when talking to the police officer.
What about just saying you'd rather not get into it, or you don't want to answer that question?
You can respectfully decline to answer that question. I've given that advice before. What I see is I try a lot of the cases here, and I will have probable cause motions, and if I win my probable cause motion, high five, we leave, you win, no further evidence comes in. When our judges are typically listening to the answers there, that respectfully declining, I don't know if that's going to go well. I think they understand you can have something and drink and drive down the road. That's not illegal, and I think you could say yes, a couple. I don't think that, or you could say respectfully decline everything. I think if you're going to decline everything right up. But when it comes to blowing at the station, it's very important how you handle that. And we'll get to that when.
Sure. And so, because I guess there's, the way I understand it, you get pulled over, and then you'll have a exchange with the officer, typically kind of demonstrating your documents, probably ask about have you been drinking, if so, how much, and then from there it can escalate to the breathalyzer alongside the road. Am I using the right term for that?
Correct. Let me take you back to when you were talking about the drinking part. You said about the question and the answering of that, have you been drinking or not? I always say to my clients, I say, really, the answer to that be like if I was in the military and my sergeant said, is my wife pretty? There's no good answer to that. I'm doing push-ups regardless how I answer that question. So that's when I say about the yes or no, or should you respectfully decline. I don't know if I was in that situation. I've never been in that situation, what I would do, but I may say a couple of beers. If I honestly had a couple of beers, I think that would be because I'll tell you, though, from there what I wouldn't do. I would not do the field test.
Yeah.
Okay.
And that kind of brings my point, because I guess if you've really had one or two, then you're probably going to be fine depending on your weight and how recent it was. You're probably going to be fine with respect to the legal limit. But if you've had 5 or 6, do you want to say I've had 1 or 2? Because one, you're misleading an officer potentially, and then second, it's probably your smell may not be consistent with 1 or 2 drinks.
Here's the problem with that. Even if you've had 5 or 6 beers, if it's been over a long period of time, you may not be over in a .08. Okay, you may not be appreciably impaired. But the problem we have is most police officers will ask you, been drinking? How much? They never ask you, when was your last beer? When was your last drink? That becomes problematic when you blow into their handheld devices. They don't get the information, because if you just drank a beer and you left, say, Portland Grill from here, and I'm pulled over on Eastwood, and the first thing they're asking me to do is blow into a breathalyzer, and I just had a drink, I could blow a 15 and had 1 beer because I have mouth alcohol. So the problem that we have when you get into, say you said you had 5 or 6, is typically they're not going to ask you when did you have those. If I was in that situation and trying to be totally honest, had 5 or 6 over a long period of time, I would add those details, because that's going to be important. I hate having my client testify in DWIs. Hopefully they've explained everything while they're on the side of the road that doesn't hurt us, and I'll go with that. All right.
Now, I thought I understood you to say that if it was you wouldn't participate in the field sobriety testing. What's the rationale for that?
Well, they're going to ask you to do, typically there's a battery of tests. Typically they're going to check your eyes. It's called the horizontal gaze nystagmus test. They'll also have you stand on one leg. They call that the one leg stand test. They'll ask you to walk and turn, which is the walk and turn test. And those tests I always joke about is LeBron James couldn't do all those tests correctly. Typically we're getting pulled over and we may have been eating at, say, brasserie, and we're wearing, or came from work, I'm wearing dress shoes. I'm not wearing athletic shoes. I'm 48 now. I'm not in 21-year-old shape. Some of us aren't, ideal weight. People are overweight. They've had injuries. You may have turf toe. Don't think about it. And it affects how you stand on one leg. You may have twerked your knee working out, running. You may be tired. There's all kinds of things about these field tests. I tell them my knees are shot. Sorry, I can't do those tests. I would not do the field test. You could also respectfully decline to do the test. You're not under oath when you're talking to the officer, but that's one thing I would not do. That I would say I'd rather not do those tests.
I've had
vertigo.
I've had a client decline by telling the officer he couldn't do those tests if he was sober.
Yeah,
which probably wasn't the best answer.
Don't use that language. Yeah. Don't use sober. I tell my clients when they're getting ready to testify, take that language out. Take the language I previously talked about, whiskey and stuff like that, out.
Well, that's interesting that you mentioned testifying, because it's my understanding that the conventional wisdom in criminal defense is that you don't want your defendant to testify.
Yeah.
Do you put your defendants on the stand sometimes in DWI trials?
Only if necessary. If I have to reveal that they had some kind of injury, you could have a DWI where we have no number, and the police or the state is trying to prove that there's appreciable impairment, meaning recognizable impairment of our mental or physical faculties, and I have to explain that my particular client had a knee injury, or several knee injuries, 2 knee injuries, something that happened in their life, and we have to kind of personalize him to the jury or the judge about why he couldn't do those tests. That severe nervous, anxiety problems, issues. I always give the field test in my office. I see things that I would never seen. People not had anything to drink, I give them the field test in my office. People that look like they're athletic, and I'm like, you're 3 touchdowns down before you even try these field tests. So that one thing I always say is not to do the field test.
So the way I understand the probable cause hearing, it's a way to say that we're not going to get into the later alcoholic result or the test of any or results of any test or what your BAC was, because the officer lacked proper justification to arrest you. What do those hearings look like where you're making that challenge if you have a client that's followed your advice to a T? The testimony from the officer being, I pulled the guy over, I smelled alcohol, saw bloodshot red eyes, they declined everything and didn't do anything, so I just took him to jail.
Yeah. Well, you don't want to give them more evidence that they can use against you. That's what you don't want to do. And any time that you're questioned by police, you could get in a story that they try to switch on you. You may, basically, I think that the less is best, because you could be nervous, you cars whizzing by, you're trying to stand on one leg, you're outside of maybe a bar area doing a walk and turn test and all that. These things can become potential problems if you try to do these field tests. And I have had some people knock them out of the park, but I'm telling you, 95% of the time, they're going to find clues, and going on probably this number that you blew on the side of the road, this is a portable breath tester, they're going to arrest you, even if they had one clue on one on the other. and I would tell you not to do the field test.
Can they still arrest you if you blow under a .08 on the toxin?
They can. They're, in North Carolina, we're a state that you're either guilty, you blew a .08 or greater, or you're appreciably impaired. Appreciable impairment, they could say, well, hey, maybe this was a first-time drinker, or they don't have a lot of experience. Definitely something was going on. They blew a .07, but hey, I gave them those field tests, and I saw 5 of 8 clues, on the walk and turn, 3 of 4 on the one-leg stand, and they would tell the judge that everything, the evidence looks like they were appreciably impaired. There's another problem with somebody who may not have been, but was nervous, trying to do the test, knew they had drank something, number comes back in 07.
Is it possible to get an acquittal, and I mean kind of a resolution on the merits of a DUI if you blow a .08 or over?
Yes, I think first of all, you can either try it on, it was bad stop, okay, the officer lacked reasonable suspicion that you violated a traffic offense. You could have a problem with a checkpoint. We haven't had as many as we used to have as far as checkpoints. You could have a problem with having all of the particular officers there that are needed, or witnesses to prove that somebody was driving. Then you have probable cause to arrest. Judges will carefully look at the totality of the circumstances. They will look at, hey, what was going on? Pulled over for registration, no real bad driving, no clues on the field test, or denied doing the field test, possibly win something at probable cause. Also, you could blow right on the number at a .08. We have a machine, I guess the intoximeter came around, I think 2006. Machines are probably 14 years old. I don't know if we're going to go to something newer. But anyways, you're not guilty by machine. I think if you can prove that there is an appreciable impairment with how they're driving, how they were talking, they were walking, things that they were doing normal, because they're looking at how somebody has lost the normal function of their faculties.
So if the device that's in front of you being the breathalyzer, and then you mentioned the intoximeter, so I guess that's if you get to the point where the officer's arrested you and then it's taking you to the station, I presume that you're going to be presented with the intoximeter or asked to blow in that.
Well, first of all, this right here is called the Alka sensor. This is a portable breath tester. Typically, you're going to see this on the side of the road. You do not have to blow into this, okay? You do not have to do field tests. Those are things that are voluntary, right? People feel like they have to. There's an officer asking you. You're not under arrest. But in a DWI is different than about any crime. You typically aren't Mirandized till after you're under arrest. The officers have a lot of leeway to ask you all kinds of questions because they're trying to investigate if you're drunk. The portable breath tester is something that they're going to ask you. They're supposed to ask you after they give you the field test. They're supposed to use this to corroborate, is it alcohol going on, or is there something maybe medical going on? Typically, however, you're going to have cops that are going to go up, ask for the license, say they smell alcohol in your breath, and they're going to ask you to blow into this thing right away. Then they're going to give you the test. So if you know what the number is here and you're judging the clues, are you going to try to find 2 or more on each one because that's an 08 or greater possibly? So that's how this kind of works.
So you think the breathalyzer can kind of taint the interpretation of the field sobriety test?
I think it can. The other thing with this is going to be interesting with COVID is COVID-19 stuff is you blow into this thing. Hopefully they put a new straw on there, okay? And I would have a concern about being pulled over without seeing a new straw in here and blowing in somebody's face with COVID, even doing the breathalyzer. I don't know if with COVID-19 going on that this step may be out. Well, they may not be doing that on the DWI.
You mentioned that the intoximeter or the breathalyzer that's in front of you is optional. Now, what the device that's at the police station. I believe that's not optional.
If you're arrested for DWI, they're going to take you down the station. They'll either take you to one of the beach places to have you blow, or the sheriff's department, or Wilmington PD. They have to read you a rights form. It's under statute 20-16.2. They have to read you a rights form that says, if you do not blow into the intoximeter, that's the big machine at the station, you will lose your license for a year. It will be deemed a refusal. Okay. You do have a right to a hearing on a refusal. There could be somebody asthmatic, attempted to blow, other things. You have hearings all the time on those. But it's crucial that if a single person that works and needs to drive should probably blow into that, because if you don't blow into the intoximeter, they can get a search warrant, get your blood, and you can have the problem of both being a refusal, and then if your blood came back over 15, you would have to have an interlock problem. There's all kinds, and they'll charge you for taking your blood. I mean, it can get expensive, but the intoximeter, I would recommend that people blow, and typically what they're going to need to do is get a witness there. The only people that typically don't go and take your blood are State Highway Patrol. If you were in a situation with State Highway Patrol or somebody that was possibly not going to take your blood and you could get around for the next year, I would say a refusal may not be a bad idea. However, I don't want to give that advice to everybody just to refuse everything, because then they may take your blood. They do in accidents, I know, in death cases like I've done, they'll take your blood. But you also have a right to have a witness present when you do the breathalyzer at the station. They have to be there in 30 minutes. So you call me, I'm at Wrightsville Beach, and you're at Carolina Beach, and you need me in 30 minutes. It's going to be very hard to get a witness. But I would think about anybody you could get to have them come and say, I want to see them blow. If they don't allow that individual back there to see you blow, that could be an issue with the state trying to get in the particular number that you blew. Okay. It also helps in case your breath, you had drank and it's extending the time since you drank, and your number may go down.
Well, what do you think about you brought up the example of the straw with the roadside breathalyzer. When you're at the police station and you're at the one that's meant to be mandatory, do you think some of those same concerns would apply with in light of COVID? Just say I don't feel comfortable blowing into this device.
I think the state or any of the police officers or state highway or deputies, they can give you one of 3 tests. Okay, they can give you blood, breath, or urine. I've never seen a urine test in all my years of practicing here. That could become one of the least invasive, easy ways to not maybe. Urine could become the test here. I mean, I started thinking about it. You're blowing, spit could be going everywhere. They're having to clean instruments or machines, the intoximeter machine. You may have a room full, 2 or 3 people in there. It's July 4th. You're using it consistently, and there could be problems as far as with the machine and cleaning the machine. So I think that can become a problem. Now the blood tests, they always have to have these blood kits on hand. We may see more blood cases because I think that's easier for them. They're not blowing and stuff like that. And that too. With
the blood, I've heard that the risk in doing that's one, the cost that you brought up, and secondly, I've heard that they tend to yield higher results than maybe the breath tests do. Has that been your experience? Or
I have some blood case results have kind of floored me what I've seen, but I've seen it both ways though. I've seen something that came back lower, which surprised me too. So I'm not sure. And blood is not isn't perfect either. I'm seeing more blood cases. I've had analysts come on drug cases. That's another topic you could really talk about, because now people are getting pulled over. I've had people charged that took Adderall. getting different cases, and they're taking a blood test, and then they're going to have somebody come and testify that something was in your bloodstream, and there's all kinds of arguments to make on those blood cases also.
So that's an interesting issue. So if you're driving, I guess, are you eligible for a driving under the influence if maybe you were taking something legal like an Adderall or a opiate or whatever you want to call it, and you're not prescribed that medication? Is that what makes you eligible for DUI?
No. You could be prescribed something. You can take a Xanax, but you're not supposed to. Some of these things say don't drive, don't operate any type of heavy machinery. It's legal for you to take it. However, we got to figure out, are you appreciably impaired? Some people that take pain medication that may not have an opioid in it. They've taken them over time and they're not impaired. They veterans, other people, maybe former athletes they're having to take them. People have had bad back problems that aren't necessarily taking oxycodone and stuff, but that are not impaired because of they have their tolerance level. I also would argue when we're talking about Adderall, wouldn't you rather that person that has ADD taking their Adderall and driving than not? Yeah. You should be more focused. I've had people say, well, they took the Adderall and they had alcohol. Okay, how many people? So many people are taking Adderall nowadays. I mean, it's and they're back to doing field tests. That's another reason if you were ADD, you wouldn't want to do field tests. Right?
Well, one of the things that I've seen you do that got a lot of notoriety was the Honeybun Defense. And can you explain a little bit about how maybe false positives can arise as a result of what you've consumed that may not be alcohol?
What we did was, it was WECT years ago, I think, and they called me about interlock devices and handhelds, and what these are. There's a fuel cell and on these particular Alka sensors and interlock machines, and they get a voltage reading. And when you are things that have yeast and things that end in ANOL, there's things that can mimic ethanol. Okay, so I do a lot of different cases, interlock hearings and things like that for people, and that's why they called me about things that could maybe set off the machine for a false positive that you haven't necessarily drank, but you've ate things. When you go to these companies, they warn you about consuming things that have ANOL and all that. So what we did was the newscaster called me, and we did a honey bun, we did Mountain Dew, and we did Wonder Bread. And what I did is I consumed the honey bun, and I think the Wonder Bread, and I had a client that just happened to come in the office and did the Mountain Dew. Two of the three had positives, the honey bun and the Wonder Bread. I was getting numbers like 0.016, almost 0.02, like having a drink from after I did the Wonder Bread, and after I did the honey bun. And so officers, we had fun with that. They said, hey, McGee, what do you have, nine honey buns? Yeah. So we had a good time.
Well, that was going to be my question, is if I was maybe at a 0.06 or 0.07, could that honey bun push me over the edge?
Hard to know, with the science. I mean, you're blowing into this machine that isn't the all cure-all. I haven't made the Honeybun Defense in court. Typically people aren't eating honey buns at 2 a.m. and all that, but if you ever try that, let me know. We'll have to try that one. We'll try it in my office one time.
All right. Well, what types of things, what are you seeing in terms of trends and how DWIs are being punished? I remember when I first started, I kind of dipped my toes into criminal a little bit, and I felt like there was enormous political pressure on the judges and DAs to always prosecute or to always win. Are you seeing that still?
Well, and DWI is really tough. If you came into my office and you were selling marijuana or had felony possession of marijuana, you have the opportunity to get a conditional discharge, maybe a deferred prosecution, have it dismissed eventually and expunged off your record. A DWI, you don't have that opportunity. We have no conditional discharges for DWI in our state. Other states have those. I know Washington State, some others. The first DWI is not on your record in Pennsylvania. A bunch of different states have other options. North Carolina got really tough. Mike Easley in 2006 changed all the laws. You can't get a careless and reckless get a DWI negotiated down to a careless and reckless. You can't get it just dismissed. We have to win it on the merits, win it at trial, unless there's big problems with the case. So the thing that I don't like about DWI is it's so political that person may not have the opportunity that made a mistake, first mistake they've ever made in their life, to get a conditional discharge, and somebody who was out selling marijuana or whatever, been doing it for a long time, or possessing, cocaine or whatever for a long time, and they're able to get a discharge.
Is there much of a benefit to pleading to a DUI?
It depends. Sometimes when you try a case, things can come out. People sometimes that are impaired can say some bad things. They can be doing some things that they would be really embarrassed about. Their punishment level could maybe go from a lesser level and climb up because of things that come out at trial. Maybe go from a level 5 to a level 3. They could be put on supervised probation if they plea. I always think it's best to have a lawyer in your situation for a DWI, and you really need somebody who knows DWIs. You can tell they're very complicated. There's a lot of issues with DWIs, and I think sometimes my advice to a client is we need to minimize the damage. I always heard that from my good friend Frank Jones, who's now in Superior Court, saying sometimes you got to minimize the damage. And unfortunately, sometimes in DWIs, when you have crashes, you don't want to bring in somebody, the victim, and bring them for a day in court to try your case when you're going to plead, be found guilty. So I think those are things that I always recommend to my client if it's going to hurt them in court.
Mm-hmm. Well, that's been a lot of great advice, and I think you've definitely gone much more in detail than I could do with this, and that I've given my friends in similar conversations like you said you've had. So I appreciate that. You mentioned earlier that you're living on the beach. What are things looking like on the beach these days?
Well, exercise only. That's is what they have it closed down to. I'm seeing more policing of just the beach. Used to, you come on Wrightsville Beach, they're very charged up to get DWIs, to get speeders, people running stop signs. I'm not really seeing any police in the median. It's been beautiful. We need the tourists back, I guess, to help fuel some of these businesses. I hope we get back on our feet, everybody, and praying for that. The other talking point I would say is kind of important is I see a lot more people making a bad decision a second time. And that's very important, because if you get a second DWI within a 7-year period, you're looking at mandatory jail time. And I think a lot of times when people are looking for some information and they've gotten a second DWI, they're really worried, which I hope they are, concerned. And there are ways that you can avoid jail time.
That's interesting, because it's my understanding that your second DWI is mandatory. Is it 48 hours in jail, or is it a week?
No, second DWI within 7 years, you'd be a level 2 DWI. You would face mandatory 7 days in jail up to a year in jail. I don't recommend that you come into court on a second DWI or third DWI or DWI where you have kids in the car without any representation. You're looking at possibility of jail time, and there are things that I recommend to my clients, to inpatient treatment, to wearing a continuous ankle monitoring device, things like that can, in lieu of jail, the legislature has created some opportunities.
How does that play out mechanically? Do you tell the judge at sentencing or plea that your client's elected to do inpatient treatment or to wear an ankle bracelet, or do you have to request the judge to allow that?
Well, the judge can give you credit for the time that you wear it prior to doing a plea. I think the judge is going to want to see that you've already gone out, if you can afford it, and made a opportunity to get the continuous alcohol monitoring device or SCRAM device on your ankle.
How much does that cost?
Being proactive. Typically $10 to $12 a day monitoring. So if you were trying to get 7 days of jail credit, you have to do 90 days of wearing this device. 90 days of the device typically going to cost you anywhere from $900 to maybe $1,050, something like that. As far as the cost, a couple companies in town that do that, but you know, those are that, and that shows the judge, you know, rather than having mom or dad or brother or wife or husband come in and say that they haven't been drinking for 90 days, that machine doesn't lie. Shows that they have done that, and judges will give you 7 days of jail credit in that situation. It can help. Also, sometimes they will consider the cost that you have spent on that device, and maybe reduce your fine in that particular situation.
How much inpatient treatment do you have to do to get credit for a required week sentence?
So you get day for a day. So you do 7 days inpatient, you get 7 days of credit.
Are you seeing that the judges favor the alcohol monitoring devices over the inpatient care?
No, I think they like both, because, you know, you're getting intensive treatment in those inpatients is a lot different than when you're doing outpatients, which is good, but they know you can't leave that facility. But I haven't really seen anything where I've gotten an opinion that any of our judges like one over the other.
And I believe the third offense is now up to 30 days, is it not?
If you're a level 1, meaning that you have 2 or more grossly aggravating factors. So say I had a DWI within the last 7 years, and I'm revoked for that DWI. I never did all my classes, I didn't pay all my fees. I'd be a level 1 facing 30 days in jail. That would be the mandatory minimum to 2 years in jail. I've seen people that have gone in court and gotten 2 years. I've seen people get the minimum 30 days. I've seen people that I always recommend to my clients, hey, you can get 20 days credit if you wear the bracelet for 120 days. That's a continuous alcohol monitoring device. I call it a bracelet because it looks like one of those Nike.
You just wear it on your wrist?
No, it's on your ankle. And there's a big surge of people wearing them in September, October when we have long pants. You know, they'll say, hey, continue my case to, you know, close to Christmas so I can wear this thing in the fall, not in bathing suit season. Yeah. So that, you know, but they can get 20 days credit, but they still would have 10 days that they'd have to go inpatient. It can get really expensive. Best not to make this mistake twice. But, you know, people with alcohol problems, typically addiction problems, and, you know, sometimes slow learners.
Understood. Well, that's very good advice, and it's certainly the punishment and the consequences have been ratcheted up in recent years with that. So it's DWIs are certainly dangerous situations, and you know, definitely need to get lawyers involved when you have that happen. So, Jimmy, I appreciate you coming on. I hope to see you down at Red Dogs and everything gets opened back up, or out there on the beach. And I appreciate your time.
Thank you. Thank you.